Good morning, everybody. This is Dan Reel with Fraud Closure 101, and we are doing yet another informative educational video that is not legal advice. This one is about the motion to dismiss. You may have heard of it, you may know something about it, but for Connecticut purposes, we're going to break it down. A lot of these principles are universal throughout every state, but I think it's necessary to just go through them, especially since in Connecticut that is the first responsive pleading that you can file. Now, the motion to dismiss is used for generally one of two things. One, to assert lack of what's called subject matter jurisdiction. That is the power and authority of the court to hear the case. And number two, lack of personal or in personam jurisdiction. Lack of personal jurisdiction comes in one of two flavors: insufficiency of process or insufficiency of service of process. Now, let's give two examples of what that might be. Insufficiency of process would be, let's hypothetically say, they served you the complaint but they didn't serve you the summons, or the complaint is 5 pages but they only served you 3. That would be, is about as simple as it gets. Insufficiency of service of process would involve a situation where maybe they didn't serve you with enough time for you to adequately respond. For example, in Connecticut, you have to serve somebody no later than 12 days before what's called the return date, which is when the clock on the pleadings actually starts ticking. So that would be an example of insufficiency of service of process. Another example would be, let's just say you had your neighbor Bob down the street serve it instead of a state marshal. That would also be insufficiency of service of process. Also, we're not really going to go into this in this video, but another ground for the motion to dismiss is called the prior pending action doctrine. What that states in a nutshell, and you can look up Bear versus Show Motion Pictures Incorporated, which is the Connecticut standard, is that if you have two different actions that are between the same parties that are virtually alike or identical and they're designed to adjudicate the same underlying rights of the parties, then the second action has to be dismissed in favor of letting the first one proceed. We used to have this thing called the plea and abatement, which served that function, which has since been replaced by the motion to dismiss. Now, if you want to look up in your handy-dandy Connecticut practice book, now this is based on the 2015 version, go to 10-30, 10-31, 10-32, 10-33, and 10-34. You will get all the information, well, most of the information you need to start doing your research from there. Now, lack of subject matter jurisdiction, this, list of 5 items doesn't cover everything, but I just briefly want to go over the most common ones. Number 1, lack of subject matter jurisdiction can be, arrived at, say, if the plaintiff doesn't have standing. Standing is established by one of two means. Either the plaintiff is classically aggrieved or statutorily aggrieved. Now, statutorily aggrieved means under a statute they have a specific cause of action. That's self-explanatory. Classically aggrieved, hypothetical example, let's just say the plaintiff owns property and you have damaged the property. The plaintiff is obviously aggrieved. Mootness, this happens every now and then. But basically what mootness is certain events have transpired and the court can no longer grant practical relief because something has happened that is, rendered the whole controversy moot. Justiciability, that's an important component of subject matter jurisdiction. Justiciability basically states, in a nutshell, that it's a clear-cut, ironclad, like there's an actual controversy, there's nothing hypothetical, and the court can grant practical relief, and the controversy is actually ripe for adjudication. In other words, if you have a contract that says Party A has to do B, C, and D before he brings the suit to court, and he does it, well, guess what? Now it's ripe for adjudication. Statute of limitations, that is another ground to have a case dismissed, and statutes of limitations differ depending on where you are and depending on the type of action. But hypothetically, if you're looking at a personal injury tort, say for example, the statute of limitations in Connecticut is 2 years. So if you wait 2 years and 1 day, well, you're too late, and the other side will file a motion to dismiss, and you're out. Finally, res judicata. This comes in two flavors, issue preclusion and claim preclusion. Okay, either way, in a nutshell, to keep this really short for YouTube purposes, res judicata basically dictates that the matter has already been adjudicated in another forum and the facts have already been established. So, in other words, let's just say the bank sues you the first time and you win. And you establish in that prior suit that they had no standing to come after you, and they file a second suit. You say, hey, res judicata, this has already been adjudicated. The court can't go back and unpack it. So I hope that's helpful, and if you have any questions, comments, headlinecopy@gmail.com. We'd be happy to answer your questions, receive your informative feedback, and if you have a type of video you want us to post, let us know, and we'll go from there. Take it easy.